chapter is the fund utilization of the society. And these bylaws talk about raising funds, the share capital, other funds that are to be kept, the repair fund, major fund, sinking fund, education training fund, and how they are to be invested. So most of the people must familiar with the way the funds are collected by the society, but there are certain clauses which restrict certain collections and certain deposits and the way the investment has to be done. And the bylaws require that the entire amount that is there in the fund should be invested together with the interest. So interest is not an income. So you first invest the thing, the fund grows, and if you need the money, then you bring it back in the accounts as an income drawn from the fund, and then you utilize it for your expenses. And even for utilizing for expenses, there are bylaws, which I will come to, which deal with how to utilize the funds. Next chapter deals with members' rights, responsibilities. Here we have the classes of members, and in classes of members, we have people who become members by purchase of the flat, people who become members by nomination, people who become members by virtue of transfer of flats, original allottees. So all the eligibilities are defined, and the class of membership is defined, and the rights of members are defined. The procedure for nomination and the resignations of members are also defined. I will take up one or two of the major things. One is nominations. Nomination is every person who holds a flat must nominate. If you are more than one person, there are two opinions. One opinion says that there will be one nomination per flat. The second opinion says that each name in the share certificate should nominate their own share of their property rights to a nominee, which means if it is a husband and wife, wife can nominate her brother and husband can nominate the son. That is permitted. There are some societies, of course, who ask for one nominee, which in my opinion is wrong, because each one has a right to nominate their own share to whomsoever they like. So this is an area where all of the participants should take care to ensure that the nominees are correctly done. Otherwise, there are problems on the death of the member. The next important thing here is the resignation and transfers. Normally, if you are selling your flat, you are supposed to give a notice to the society. 8 days before, no permission is needed. And even if you are renting a flat, you have to give notice to the society. No permission is required. And thereafter, submit the relevant documents. The next chapter deals with the responsibilities, which is for members and responsibilities of the committee. If it is the question of responsibility on maintenance, these are all to be done in the general body, and there are headings under which the funds can be collected. So everybody has to understand that responsibilities of committee and responsibilities of members are all defined, and there is nothing which is super over the laws which you have to follow. Now we come to the next chapter, which deals with, before I move on to this chapter, in the case of transfer, this is very important. You have cases where you transfer the flat, you buy a new flat, or there is a nominee who comes in the name of the previous owner, and the society continues to charge them outstanding of the previous bills. Now the requirement is very simple, that the liability is only for 2 years, and society has to collect the money within 2 years. If they fail to collect the money, the past members' dues cannot be collected from the new member. This is very, very vital, which normally gets missed out. So the liability for past members is limited. There's a limitation there for 2 years, within which society has to approach the registrar under the relevant section and collect the money from them. And then they can also join the new person as an occupier, which is permitted in the Act. But if society fails to do that, then they cannot get the benefit of the old one if it is challenged in the court. The next chapter is about levy of charges. Now in levy of charges, we find penalty as one charge, and penalty is basically for breach of bylaw. You cannot have a penalty for something which is not in the bylaw, because penalty is directly related to the agreement between members, and the penalty will come only if some member defaults or some member violates the agreement. So we cannot have a situation where the headings are created If new headings are created, then it would need approval of registrar because that would amount to amendment of the bylaw. The next chapter deals with the duties and powers of the society. Now, in the duties and powers of the society, we are actually talking about the managing committee, because managing committee represents the society to function and manage the affairs of the society. So there are certain things that have to be done. And the important things which are troubling everybody is structural audit. So it has been defined that if the building has attained an age, particular age, you have to do a structural audit. Structural audit has to be brought before the general body. And from the repair fund, you have to use the funds to do the repair every number of years as specified in the bylaws. The second thing that is defined in this particular chapter is the parking rules. Now, many people are having problems of parking because the open parking, where parking has allotted by the society, has to be done as per the bylaws. And the bylaws are very clear that if you need parking to be done, you have to make rules. The general body will approve the rules. Committee will mark out the area which is available for parking. It will come before the general body. General body will lay down the rules under which the allotment should be done. And then prices have to be fixed, and the job of the committee then is to allocate it based on the approval of the rules as given by the general body. And in the rules, normally the specification is also given in the bylaw that if it is one car, then everybody gets it. If you have a second car, only if there's a space left after giving everybody who has the car in his own name and is parking it in the compound, then it will be shared between the number two cars. And if more space is left, it will go on to the third, fourth, and fifth car, and so on. So these are the things which are already there in the bylaws. But in spite of that, we have a situation where members have problems because obviously they do not or have not read the bylaws. Next section that we will be going is regarding general meeting and power of the general body. General body is supreme, and they are the ones who elect the committee members. So committee members have to ensure the power delegated to them is what is followed by them. So the committee has to make sure that the powers delegated, because the act is very, very clear. General body is supreme, section 72, and the committee is delegated the powers by the general body. Now, when we come to the powers of general body, we also have in the bylaws what are the powers of the managing committee. And many people are of the opinion that the managing committee has a lot of powers. Technically, in the bylaws, the word power is not used except in one place, which I will come to, and the bylaw deals only with the functions. So every office bearer has been given a function, and for the function, a procedure has been laid down. So you have to follow the procedure as has been laid down, and you have to follow the laws as has been laid down. And this is one area where also a lot of disputes come because members do not read the bylaws, which specifically lays down the procedure when you give an application, the procedure when the application has to be brought before the managing committee. Even if there are no problems and it is incomplete, even an incomplete application cannot be returned back. It has to come before the managing committee, and managing committee has to decide to return it back or give instructions to secretary as to what has to be done. So everywhere we have a situation where the powers are given, and it's only the committee as a whole that has the power, and they have to decide and then authorize the secretary to take action based on the decision of the managing committee, because that is how the functions are clearly listed. So far as the treasurer is concerned and the chairman are concerned, the chairman has been given a power, and the bylaw has one section which says the chairman has the power to issue any directions in place of the committee, but he has to put the reasons down in writing why he is exercising that power, and at the next meeting of the managing committee, that decision has to be ratified. Now these decisions have to be considered because there are sometimes there may be a fire, or there may be a calamity, or there may be an accident, or there may be such situations where a meeting cannot be called. And obviously all the members cannot get together. So it becomes the responsibility of the chairman to take a decision within the law and the rules permitted and make a particular direction. but also make sure that he gives his reason in writing. And thereafter, first committee meeting has to endorse it and approve it. So that is so far as the general body powers and functions are concerned. Now we come to the point of general body meeting, and a meeting has to be held every year, and which is called the annual general body meeting. In addition to that annual general body meeting, as many meetings that the society wants can be held, either by requisition of the members or by the requisition of the managing committee, or a chairman can also issue notice, or a secretary can issue notice approved by the managing committee to hold a meeting for a specified agenda. Or the registrar can order that a meeting should be called to approve a particular agenda. There is one anomaly which is normally missed out as to who is going to be the chairman of the meeting. The bylaws are very clear on this, that the meeting shall be chaired by the chairman of the society, or in his absence or his not inclination to be the chairman of the meeting, by any other member present at the meeting who may be elected by the general body. Meaning thereby that it is not automatic that if chairman is not there, secretary becomes chairman or any other office bearer becomes chairman. No. It is a meeting of the members, so members have to elect a chairman. The second problem that has come and which is noticed is where you have an administrator or an authorized officer. Many a times you will find that a meeting has been called by the authorized officer, suo motu, putting in certain agenda, and the authorized officer chairs the meeting. He cannot chair the meeting because it is a meeting of the members and he is not a member. The only point where an authorized officer can chair a meeting where he is so authorized by the registrar, because the authorized officer is working directly with the powers of a committee but under the instructions and directions of the registrar. So in case he does something and there is no direction given by registrar which you can get under RTI, then the members can straight away apply to the registrar that the administrator has acted out of turn and report to joint registrar, and his panel membership would be cancelled because there are certain conditions on which the administrators can be cancelled. We come to the next item, which is the maintenance of accounts and registers. Now, this particular chapter 13 deals with all the registers that are to be maintained. There are more than 20 registers, and the committee has to make sure that they comply with all these requirements. The registers are maintained and they are brought up to date, and members have a right to inspect the registers, and in case it contains information of other members, then only those pages where his own or her own information is there, he would be allowed to see. He cannot see the information of other members. The reason is because the rights of privacy of members has to be protected. Now, while we are on the rights of members, there are issues where the outstanding of members are also mentioned on notice board, or outstanding are mentioned in the accounts. Now, these are certain things which the general body agrees that defaulters list will be published, because it is permitted by law to have a defaulters list when you are having elections. So in the case of elections, a defaulter cannot run, and therefore a defaulter list has to be published. So from that point of view, it can be published. Otherwise, it is a privacy right which has to be also considered. One of the reasons is that many a times the outstanding shown against a member is not a genuine outstanding. It is an outstanding which has been created because of a problem between a member and a society or a committee, and they inflate the bills, or the committee may charge penalties which are not yet disputed and show them as defaulters and declare the member as having a large outstanding. So these are areas also where the bylaws have got provisions which one can understand and read and accordingly take remedy. Apart from that, we also have in this chapter the filing of returns. Now, the society has been mandated that after every financial year, they have to file and submit to the registrar an annual return in a particular format, and it is called Form Y. So please remember this, is called Form Y, and in that format you have to submit the return. Many times returns are submitted just with a simple letter and not in the format, which will then be violation of the bylaw. Now, while we come to Form Y, I would also go back to the general meeting where there is something called Form X. Now, in the olden days, we used to have a general body notice, which used to have many items, and at the end, we used to say any other item with the permission of the chair. The old bylaws also talk about any other item by the permission of the chair. Now, in the amendment of 2019, the amendment says that any item that you are putting in the notice should have a notice. So you cannot bring in items which are not in the notice. So in the Form X, a full definition has been given of what should be part of the general body notice. And even in section 75, which deals with general body, उसमें बोलता है कि जनरल बॉडी को अपना मीटिंग करने का है और नोटिस इशू करना है सेक्शन 75 के हिसाब से. अभी सेक्शन 75 में बोलता है कि आपको नोटिस इस तरीके से इशू करना है एज प्रिस्क्राइब्ड, और अगर हम नोटिस उस तरीके से नहीं इशू करेंगे, दैट मीन्स द जनरल बॉडी का मीटिंग जो है इज नॉट हेल्ड एज पर लॉ. तो इट्स वेरी वेरी इंपॉर्टेंट कि वो नोटिस जो है, एजेंडा जो है, वो पूरा आना चाहिए. और एजेंडा में आइटम्स जो हैं, बजट आता है तो बजट देना पड़ेगा. आइटम में आप ऑडिटर का जो स्टेटमेंट आता है उसके ऊपर रेक्टिफिकेशन किया है, वो डिस्कस करके वो डिटेल आना चाहिए. तो उसमें पूरा आइटम दिया हुआ है और वो आपको फॉलो करना है. और काफी अगर कमेटी नहीं फॉलो करती है तो फिर वो वायलेशन होता है. एंड देन वो सेक्शन 75(5) में देयर इज अ प्रोविजन दैट इफ द मीटिंग इज नॉट हेल्ड एज प्रिस्क्राइब्ड इन 75, then the committee can be removed. तो जो prescribed का procedure है वो follow करना बहुत ही जरूरी है. Next item that comes is appropriation of profit. अभी appropriation of profit although society को बोलते हैं कि वो no loss no profit का situation है, लेकिन फिर भी bylaw में बोलते हैं appropriation of profit, जिसको आप read करेंगे surplus. जो सरप्लस आया है आपका मेंटेनेंस कलेक्ट करने के बाद, खर्चा कम हुआ तो उसको हम प्रॉफिट बोलेंगे. और वो प्रॉफिट का 25% रिजर्व फंड में डालने का है. एंड 75% कैन बी स्पेंट ऑन अदर थिंग्स विच आर ऑल्सो स्पेसिफाइड. वो भी स्पेसिफाइड है, वी कैन नॉट गो एंड स्पेंड. और जो दूसरे आइटम्स भी हैं जिसको स्पेंड करना है उसके ऊपर भी देयर आर कैप्स. So you have to follow the cap on which this has to be done. अभी एक और है अप्रोप्रिएशन ऑफ प्रॉफिट में है कि रिजर्व में डालने के बाद यू हैव टू ट्रांसफर द मनी टू बोनस फंड, यू हैव टू ट्रांसफर द मनी टू रिजर्व फंड, यू हैव टू ट्रांसफर द मनी टू अदर फंड्स. और कौन से फंड्स क्रिएट कर सकते हैं वो सब बायलॉ में लिखा है और वो हमको वही फंड्स फॉलो करना है. हम अपने मन से डिपॉजिट या फंड नहीं क्रिएट कर सकते हैं, तो वो ध्यान रखना है. अभी अगर हम बोलते हैं कि हमको फंड क्रिएट करना है और बोनस देना है, तो उसमें एक सर्कुलर है गवर्नमेंट का, जीआर है, जो बोलता है कि अगर आपके बिल्डिंग में, तो ये बायलॉ में नहीं है बट बोनस का चैप्टर है इसलिए मैं मेंशन कर रहा हूँ, कि अगर आपको होल्डिंग है या आपके पास मोबाइल टावर है तो फिर आपको वो मोबाइल टावर के इनकम के ऊपर जो टैक्स भरना है वो भरने के बाद 50% हैज टू बी डिस्ट्रीब्यूटेड एज बोनस टू द मेंबर्स एंड 50% हैज टू गो टू द सिंकिंग फंड. इसका मतलब है कि ये जो पैसा आएगा आपको बोनस फंड में क्रेडिट करना है और 50% आपको सिंकिंग फंड में क्रिएट करना है और उसके बाद में आपको बोनस फंड में से बोनस डिस्ट्रीब्यूट करना है सब मेंबर्स को. और ये पैसा आप दूसरे खर्चों में नहीं डाल सकते हैं. अगर आपको डालना है तो आप उसका बजट लीजिए, अप्रूव कराइए और मेंबर से कलेक्ट करिए. तो एडजस्टमेंट ऑफ इनकम अगेंस्ट एक्सपेंसेस, उसके ऊपर रूल्स हैं जो फॉलो करना है. नेक्स्ट आइटम आता है अप्रोप्रिएशन में. मैनी टाइम्स वी हैव सिचुएशन कि किसी ने पैसा नहीं दिया है, सोसाइटी ने रिकवरी नहीं किया है और रॉन्ग डेबिट हुआ है, रजिस्ट्रार का ऑर्डर आया है कि भाई डेबिट रॉन्ग है, या सोसाइटी ने 101 में या जो नया 154 है उसमें रिकवरी के लिए अप्लाई किया है और वो डिसमिस हो गया है, तो फिर वो अमाउंट आप नहीं कलेक्ट कर सकते हैं. तो वो इरिकवरेबल ड्यूज में आ जाता है. is to be treated as recoverable dues and it has to be passed in the general body. उससे पहले ऑडिटर को बताना पड़ेगा कि भाई ये ऐसा सिचुएशन है. The orders have to be disclosed to the auditor. Auditor will study everything और फिर वो ऑडिट रिपोर्ट में रिमार्क डालेगा कि ये पैसा इस रीजन के लिए नहीं कलेक्ट किया कि यहाँ तो मैनेजिंग कमेटी ने राइट टाइम में लिमिटेशन के अंदर अप्लाई नहीं किया था, तो वो पैसा जो है भी ड्यू रिकवर नहीं हो सकता है, या रॉन्ग आइटम था तो नहीं रिकवर हुआ, या जो भी रीजन होगा, और उसके बाद जनरल बॉडी विल अप्रूव कि इसको हमको राइट ऑफ करना है, एंड देन सैंक्शन मिलने के बाद इसको राइट ऑफ कर सकते हैं। अभी यहाँ पर एक और पॉइंट आता है विच इज नॉट इन द बाय लॉ बट इज रिलेटेड टू द बाय लॉ, और ये है अकाउंट्स का मैटर। क्योंकि अकाउंट्स के मैटर में बहुत ही प्रॉब्लम्स आते हैं, और बाय लॉ में क्लियरली लिखा है कि ऑडिटेड अकाउंट्स सबको देना है, जनरल बॉडी में अकाउंट सबको देना है। तो वहां पर इशू उठता है कभी कभी कि अकाउंट्स में क्या देना है और क्या नहीं देना है। तो वी हैव टू रीड इट टुगेदर विद द रूल्स। नाउ देयर आर रूल्स व्हिच से दैट जब ये अकाउंट्स बन गया, एज सून एज द अकाउंट्स आर रेडी, they have to be displayed, open for display of the members for 15 days before they are sent to the auditors. मतलब एक नोटिस लगना चाहिए कि ये अकाउंट्स रेडी हो गए हैं, आप आके देख लो बिफोर वी सेंड इट टू द ऑडिटर्स। इसका मतलब अगर हमको कोई भी प्रॉब्लम है या हमको कुछ भी है अकाउंट्स में जो हम एग्री नहीं करते हैं, वी हैव टू टेक इट अप विद द मैनेजिंग कमेटी प्रायर टू सेंडिंग इट टू द ऑडिटर्स। तो मैनेजिंग कमेटी को फिर वो हमारा एप्लीकेशन कमेटी में रख के उसका रीजनिंग देने का है, और ऑडिटर को बताना है कि ये ऑब्जेक्शंस आए थे, क्योंकि ऑडिटर सबका मैनेजिंग कमेटी का मिनट्स देखना है ऑडिटर को कि ये ऑब्जेक्शंस आए थे और ये हमने किया है। ऑडिटर विल देन डिसाइड ये ठीक किया कि नहीं किया, उसके ऊपर फिर वो अपना रिपोर्ट बनाएगा। अगर उसको लगता है गलत है तो फिर वो ऑडिट रिपोर्ट में डालेगा, फिर वो घूम फिर के फिर जनरल बॉडी में आ जाएगा, और ऑडिट रिपोर्ट में और रेक्टिफिकेशन रिपोर्ट में वो आ जाता है। तो सर्कल इज वेरी कंप्लीट, पर हम मिस कर जाते हैं बिकॉज वी हैव नॉट रेड द बायलॉज वेरी केयरफुली। उसके बाद में जब अगर हम डालते हैं अकाउंट्स और फिर ऑडिटर के पास जाता है, ऑडिटर ऑडिट करता है, तो कमेटी को उस वक्त ऑडिटर आया है बिल्डिंग में, उसका नोटिस भी लगाना है, नोटिस बोर्ड में सब करस्पॉन्डेंस लगाना होता है, एक नोटिस बोर्ड मेंटेन करना है जिसमें मिनट्स लगाना होता है, ये सब भी बायलॉ में कवर हुआ है। और ऑडिटर आया है तो वो भी बताना है कि ऑडिटर चालू है इस तारीख से इस तारीख तक। ये जरूरी क्यों है? क्योंकि सेक्शन 81 है जो बायलॉ में नहीं आता है बट एक्ट में आता है, एंड बिकॉज हमको साथ में पढ़ना पड़ता है एक्ट, रूल्स और बायलॉ। सेक्शन 81 बोलता है कि ऑडिटर हैज टू रिपोर्ट ऑन द वर्किंग ऑफ द मैनेजिंग कमेटी। तो अगर ऑडिटर को वर्किंग कमेटी के पर रिपोर्ट लिखना है तो ही हैज टू नो कि व्हाट आर द प्रॉब्लम्स सो दैट ही कैन हेल्प टू फाइंड द सॉल्यूशन इन अ कोऑपरेटिव स्पिरिट, एंड एवरीबॉडी हैज टू वर्क टुगेदर। कि अगर किसी को एजुकेशन नहीं है, नॉलेज नहीं है, तो दे कैन गेट द एजुकेशन एंड नॉलेज फ्रॉम द ऑडिटर और फ्रॉम द रजिस्ट्रार, एंड मेक श्योर कि किसी मेंबर को या कमेटी मेंबर को तकलीफ ना हो। बिकॉज सब कमेटी मेंबर भी ऑनररी हैं और सब कमेटी मेंबर भी अपना टाइम देते हैं, एंड मेनी अ टाइम्स दे मे नॉट ऑल्सो रीड द बायलॉ और दे मे नॉट हैव एक्सेस टू सर्टेन इंफॉर्मेशन, क्योंकि एक्ट बहुत कॉम्प्लिकेटेड है, रूल्स और भी कॉम्प्लिकेटेड है, और जजमेंट्स और जीआर अगर हम पढ़ेंगे तो और भी कॉम्प्लिकेटेड है। और अगर हम सबको साथ में देखेंगे तो फॉर अ ले पर्सन हु इज अ फ्लैट ओनर एंड नॉट एक्सपेक्टेड टू बी अ लीगल माइंड, it becomes difficult. So it is very very important that you treat bylaw को जैसा यूजर इंस्ट्रक्शन मैनुअल होता है। आपने कोई सामान खरीदा तो आपको एक यूजर इंस्ट्रक्शन आता है, तो बायलॉ भी वैसा है, तो सबको पढ़ना चाहिए। एंड देन पढ़ने के बाद क्लियर है, उसमें अगर कोई सेक्शन का मेंशन है तो उस पर लिखा होता है कि ये सेक्शन पढ़ो, गूगल में जाके आपको सेक्शन मिल जाता है, तो आपको थोड़ा समझ आता है। अदरवाइज ऑडिटर से पूछेंगे तो ऑडिटर आपको गाइड करेगा। अभी आता है उसके बाद में नेक्स्ट चैप्टर दैट वी आर गोइंग टू लुक एट is कन्वेंस एंड रीडेवलपमेंट। अभी कन्वेंस और रीडेवलपमेंट में जो भी है हमारा वो पूरा प्रोसीजर है ऑब्जेक्ट से निकलता है। जो पहला ऑब्जेक्ट है जो मैंने शुरू में बताया था, इन केस सम पीपल हैव मिस्ड आउट, आई विल टेक यू बैक देयर, एंड द फर्स्ट ऑब्जेक्ट इन द बायलॉ इज टू टेक कन्वेंस। तो अगर आप देखोगे बायलॉ में, बायलॉ शुरू होता है, उसमें होता है बायलॉ ऑफ सो एंड सो सोसाइटी, फिर बोलता है कि इसमें ये एरिया में आता है, फिर उसके बाद उसका ऑब्जेक्ट आता है बायलॉ नंबर चैप्टर 4 में, और उसमें पहला आइटम है टू गेट कन्वेंस। और कन्वेंस में काफी तकलीफ होता था लोगों को, इसीलिए अभी बायलॉ में भी लेके आए हैं कि कन्वेंस का प्रोसीजर कैसे फॉलो करना है, कन्वेंस के लिए क्या पावर है अपने कमेटी को, क्या रिक्वायरमेंट है कमेटी को, वो सब भी उसमें लेके आए हैं। नेक्स्ट आइटम ऑन दी chapter, which is chapter 19, which deals with redressal of members' complaints, और इसमें लेता दिखता है कि आप अपना कंप्लेन किसके पास लेके जा सकते हो, और यहाँ क्लियरली डिफाइन किया है कि कौन सा आप कंप्लेन रजिस्ट्रार के पास लेके जा सकते हैं, कौन सा कंप्लेन आप कोऑपरेटिव कोर्ट के पास लेके जा सकते हैं, कौन सा कंप्लेन आप सिविल के पास लेके जाते हैं सिविल कोर्ट में, कौन सा म्युनिसिपल अथॉरिटी में, कौन सा पुलिस में, कौन सा जनरल बॉडी में और कौन सा फेडरेशन में। आपको फेडरेशन में भी कंप्लेंट डालने का
We will take one or two questions now.